This is a meeting of the Metropolitan Board of Ethical Conduct. It is November 8th, 2022 at 9:30. We'll now call this meeting to order, and I will ask Mr. Kyle to take the roll.
Sure. Ms. Diani?
Here.
Ms. Carpenter?
Here.
Mr. Patton is not present. Councilmember Toombs is not present. Mr. Spraggins?
Here.
And Ms. Stewart?
Here. And we have a quorum.
We have a quorum.
That brings us to approval of the minutes of May 19, 2022. A copy of the minutes was sent to all of the members. I hope everyone's had an opportunity to review them. May I have a motion to approve the minutes?
Motion.
Second.
Any discussion? Hearing none. Can you take the roll?
Yes. Ms. Toombs is now present.
And so we have a motion, take the roll on the motion.
To retake the roll.
So we're going to approve the minutes. We have a motion and a second to take by roll call.
Okay. Ms. Diani?
Yes.
Ms. Carpenter?
Yes.
Mr. Spraggins?
Yes.
And Ms. Stewart?
Yes. Great, thank you. So the motion passes, the minutes are approved. I'd like to just interrupt for a moment to welcome our new council member, who is our ex officio, Councilmember Toombs.
Thank you.
Thank you for joining us. That brings us to item number 3, notice of appeal rights. And again, I will ask our board secretary to provide that announcement.
After a contested hearing by this board, a party may appeal to the Chancery or Circuit Court of Davidson County by filing a writ of certiorari within 60 days. Any party wishing to pursue an appeal is encouraged to seek independent legal counsel to ensure that deadlines and procedural requirements are satisfied.
Thank you. That brings us to item number 4, which is discussion and analysis of the complaint and Metro legal memorandum regarding the matter captioned Weatherspoon versus Councilmember Stiles. And as we do, I will, why don't we direct our attention to legal, and I would ask Ms. Becky if she would be able to give us a brief summary of your legal memorandum on the
Sure.
complaint.
Sure. So the complaint alleges that Ms. Witherspoon's vehicle with a flat tire, which was parked on a public road, was towed by Performance Towing and Recovery based on authorization provided by the council member. The complaint alleges that the council member failed to follow proper protocol and misused her official position with the Metro Council by contacting Performance Towing and authorizing the removal of Ms. Witherspoon's vehicle from a public road. The allegations in the complaint involve sections 2.222.020D, I, K, and M of the Standards of Conduct. Under the provisions of the Metro Code, the Police Department and the Department of Codes Administration are the Metro entities that have the power to authorize the removal of vehicles from public roads. Section 2.222.020D of the Code prohibits employees from accepting or soliciting cash if the payment or solicitation is related to their Metro government position. The complaint does not contain facts which reflect that the council member accepted or solicited money related to her official position. It is the opinion of the Department of Law that the facts alleged in the complaint are insufficient to give rise to a violation of section 2.222.020D of the Standards of Conduct. Section 2.222.020I of the Code prohibits employees from using their positions improperly to secure unwarranted privileges or exemptions for themselves, relatives, or others. It's the opinion of the Department of Law that the allegations in the complaint that the council member used her official position to illegally have Ms. Witherspoon's vehicle removed from a public road by performance towing, if true, could violate the provisions of section 2.222.020I of the Metro Code. Section 2.222.020K of the code states that employees shall not give reasonable basis by their conduct the impression that they are unduly affected by the kingship or influence of any person. The complaint does not contain any specific facts about kinship, friendship, or business relationship between the council member and performance towing. It is the opinion of the Department of Law that the allegations in the complaint are inadequate to establish a violation of section 2.222.020K of the Standards of Conduct. Section 2.222.020M of the Metro Code provides that employees shall not violate requirements of state law regulating the conduct of county officials. Section 39-16-402 of the Tennessee Code prohibits a public servant with intent to harm another from intentionally or knowingly committing an act that constitutes an unauthorized exercise of official power or committing an act under color of office that exceeds the public servant's official power. It is the opinion of the Department of Law that the allegations in the complaint concerning unauthorized exercise of official power by the council member, if proven, could be deemed to be a violation of section 2.222.020M of the Standards of Conduct. In summary, it is the opinion of the Department of Law that the allegations in the complaint, if proven, could be deemed to be a violation of sections 2.222.020I and M of the Standards of Conduct. Therefore, the Department of Law recommends that the board hold a hearing on the complaint.
Thank you. Before we start any discussion of the complaint and the memorandum, are there any questions for Ms. Ecke in terms of clarification? Okay. Then I will propose that we consider, as Ms. Ecke just outlined, really four statutory provisions under the code that are applicable, that was addressed, that was alleged and addressed. So of the four, my understanding is as to two of them, the law department's memorandum recommends that there was insufficient facts alleged to go forward on those two. That's D and K, were insufficient factual allegations to support those charges. And then as to the other two, there were sufficient facts alleged in the law department's analysis. And the question there with respect to the other two, D and M, no, I'm sorry, I and M would be a factual question. So perhaps we can have a discussion based on breaking those two down. So we can look first at the law department's recommendation as to the provisions relating to subsection D and subsection K as insufficiently factually alleged. So that's my proposal, so if we can start with those two. Any comments or thoughts about those two provisions? The first being, D is the one that deals with accepting money related to official position. And K is the one relating to improperly enjoying the influence or unduly enjoying their favor of a person in the performance of their duties. And as to D and K, the law department's analysis suggests that there are just no facts alleged in the complaint. Does anyone have any thoughts or questions about that or want to make a motion? Yes.
With respect to D, I agree that there's not evidence of improper money moving around here, so to me, the law department's recommendation on D makes sense. I think K is a closer call personally because, I guess you could potentially conclude that she's alleged that the towing company unduly enjoys the favor of the councilwoman in the performance of her official duties. However, I agree it's a pretty threadbare allegation, and frankly, the same conduct is really covered by the other pieces of the code that Metro Legal has recommended we go forward with. So at the end of the day, I'm not sure that it matters too much. If K is not the best fit, I think the other two allegations are. So I'm prepared to accept the guidance of Metro Legal on this.
Okay. So,
I do have a question.
Yes.
And I don't know if legal can answer this or not. Under K, one of the allegations is that Ms. Stiles contacted an independent towing service, not one that was legally authorized by Metropolitan government. Are there towing services legally authorized by Metropolitan government? In other words, if there's a car blocking a street and the police need to move it, is that referring to, what that refers to, there are towing companies that Metro has authorized?
Well, police, if there's a car towing, causing a safety hazard, police can authorize that, and there are wreckers that operate in certain regions
Okay.
that will be contacted to then remove that vehicle. So there, in different regions, there are wreckers that are authorized to
Okay.
remove vehicles depending on the region or
Right.
the county.
Okay, so hypothetically speaking, if this vehicle had not been removed by October 4, otherwise, one of those wreckers operating in that region would likely have been what Metro called to remove it.
Yeah, Metro will be the one to do that.
Right,
The authorized
sure.
Metro official, like police, can do that.
Yeah, okay, that's helpful, thank you.
Yeah.
I think I agree with the Department of Law recommendations on D and K. Mainly D because of I don't see enough from the complaint for any solicitation of any type of cash. Even the complaint says it can be inferred, and I don't think inference is enough. K, I think, is covered too by sections I and M. That is a closer call, I agree with that, but I feel like that's already covered by sections I and M, so.
perhaps we can take individual votes as to each of the provisions. Why don't we do that? And why don't we start with D, since I think I'm hearing most consensus on that, and I agree with the statements made about D. So may I have a motion then with respect to subsection D?
So moved, that
Okay.
we would not go forward on subsection D.
So with respect to subsection D, the motion is that we would adopt the recommendations of the legal department and decline to move forward on this. Okay, actually dismiss it as to the extent, the complaint with respect to the assertion of a violation of subsection D. That's the motion. May I have a second?
Second.
Okay. Any further discussion? Hearing none, can we take a roll call vote on that?
Sure.
motion?
Ms. Diani,
Yes.
Ms. Carpenter,
Yes.
Mr. Spraggins,
Yes.
and Ms. Stewart.
Yes.
It's 4 in favor.
Okay, so we have just voted to dismiss the complaint to the that aspect of the complaint relating to for alleged violations under subsection D. So we will not go forward on those allegations. Let's now turn to subsection K allegations regarding the allegation that council member was unduly affected by kinship or influence of the towing company. And there, I've heard two members say that it is that those allegations are better covered in I. Was that accurately reflecting your view that I is a closer match?
Yes, I think that I captures a little bit broader conduct in its language, and that the factual allegations that underlie K will be addressed in I and M, frankly.
I'll make another motion that we, I guess, adopt Metro Legal's recommendation for subsection K and dismiss that portion of this claim.
Okay, we have a second.
Complaint.
Second.
Any further discussion? Hearing none. Let's take a roll call on that, thank you.
Ms. Deani,
Yes?
Ms. Carpenter,
Yes.
Mr. Spriggins,
Yes.
and Ms. Stewart.
Yes.
There's 4 in favor.
4 in favor of dismissing the complaint relating to the allegations regarding subsection K. And that leaves us with the 2 remaining, which is subsection I, which is the retaliation claim, that there was a use of an official position for purposes of retaliation, or that is the subsection I, and then we have M. So why don't we turn our attention to I and have discussion on that point. Again, the law department has said that if true, the facts alleged, that it would, could support a finding of a violation under this provision. So that would mean as a legal matter, the facts alleged are sufficient to allege a violation. And the question for us then would be whether it was factually established. Does anyone have any thoughts or questions with respect to that charge?
Am I allowed to ask questions? No, I don't vote.
Yes.
So, with the unwarranted privilege or advantage, something that gives the municipal official something otherwise not available to the public at large, in this instance, a car was towed. So I'm not understanding what the unwarranted privilege or advantage would be in having someone's car towed. What's the advantage to the individual that has the car towed?
Well, the first thing is that only certain officials can exercise that authority, that enforcement authority. And so if anyone sees something that they don't like, for whatever reasons, they don't get to take the law into their own hands to effectuate the change or whatever they want. You have to go to the proper protocol. So if this is true, the unwarranted privilege is that, the allegation includes that there is a retaliatory motive. And so basically the unwarranted privilege, if true, is that you get to have something done which you want to happen by using authority that's unjustified and unauthorized. It doesn't have to be something that has a pecuniary interest to you or monetary advantage to you. It can be for any reason, whether it be you just don't want cars of this particular person on the road, you think it shouldn't be there, you have a problem with this person. So it can be for a variety of personal reasons. But the bottom line is that it is unjustified and it's unauthorized. And it's something that the public are not authorized to do. That is to call any towing company to remove vehicles that are on a public right-of-way, public road.
And also, am I correct that the allegation is that she got it towed before the time by which the complainant was supposed to comply according to codes?
Yes, the complaint alleges that there's a notice that was issued by codes, but directed that the vehicle be removed by a particular date, but before that date, this vehicle wasn't properly removed.
So just to make sure I'm understanding, the unwarranted privilege is using the power to have it towed, using the official position to have someone's car be towed when, but for the official position, there'd be no privilege, no right, no authority to have it towed. So
Correct.
that was the unwarranted privilege,
Yes,
exercising the power to have the car towed.
correct.
So, again, on, any follow-up questions or?
So a private citizen can't call a tow company and have a car towed?
Not on a public right-of-way.
Okay.
They can call police,
Okay.
or they can contact codes, and then police can do that.
Okay.
But a private citizen doesn't have the authority to exercise that right.
Okay, so then we are on I, subsection I. And again, legal department has found sufficient allegations if proved. So may I have a motion then on this subsection of the complaint? Does anyone have a motion to propose?
Sure, I'll move again. So I would move that as to subsection I, we would adopt the opinion of the law department that the allegations would be sufficient if proven true. And therefore, we should move forward to have a hearing on subsection I, the allegations under subsection I.
Okay, is there a second on that motion?
Second.
Okay, any further discussion? Hearing none, take the roll.
Ms. Deani?
Yes.
Ms. Carpenter?
Yes.
Mr. Spraggins? Yes. Ms. Stewart?
Yes.
Four in favor.
Okay, so that motion adopts the recommendation of the law department as to this subsection. And we will proceed on that portion of the complaint. And then turning to the last section, which is subsection M, which is kind of a catch-all provision which reads the kind of state law into the code. And specifically, the portions of the code read in through the portions of the state law which are read in to the code through this subsection of the standards of conduct that law department has highlighted for us as most relevant are those relating to an unauthorized exercise of official power and taking acts under the color of law that exceeds the public servant's official power. So that's the nature of the allegations under this, of the nature of the allegation, the alleged violations under this subsection. Any discussion with respect to this portion of the law department's recommendations?
I would just note that this one actually expressly says with intent to harm another, which seems to be perhaps even more on
Yes.
point of the allegations here.
Yes, thank you for that. Yes, I think that's very relevant. With intent to harm another. So that said, are you proposing a motion?
I would move to adopt I'm sorry, Bridget is still here.
It's okay.
You were on a roll, but I'll move to adopt
Trying to,
the legal department's recommendation with respect to 2.222.020M.
and I will second that motion. And ask the clerk to take the roll.
Ms. Diani,
Yes.
Ms. Carpenter.
Yes.
Mr. Sprague,
Yes.
and Ms. Stewart.
Yes.
It's 4 in favor.
Okay, so we have just voted to include, going forward, the subsection M as part of the legal framework, which we'll be examining at hearing. So we've just voted to proceed to hearing on this complaint as to those two provisions. And at this point, really, it's just open for discussion about next steps procedurally. Any questions? And I know we have a new council member joining us, so did you have any questions procedurally or?
I do.
Yeah.
So, we get to the hearing, both sides put their evidence on. What are the board's options once you've heard all of the evidence? Is it that you have to take some type of I don't know, is it called disciplinary action, some type of disciplinary action, or can you hear it and say, yes, this may have happened, but we don't feel it warrants any further action? Is that on the table?
So we would make findings of fact, and then our power is really, it's within the code what we can do, but everything we can do is basically a recommendation.
Right.
Or a referral. And I'm sure law department has handy,
And that's the recommendation to council, right?
yes, we can make a referral.
Yeah, so you can,
We can
As a chair.
independently decide, if we find a violation, then we would turn to our authority as to how we can proceed. And we have at least four options, and two of them, I believe, are referrals.
Yeah, one of them is to recommend to council that the elected official be censured. And then two are referrals, to refer, if applicable, to refer the matter to the director of law. A request that appropriate civil action be instituted. And if applicable, to refer the matter to the district attorney general for appropriate action. And then the last one is to recommend to the official that the official resign their position.
So
That
there's,
it's, if the board finds that there has been a violation, it shall take one or more of those actions.
So refer to the council for censure, recommend to the council that the member be censured, refer to the Department of Law for civil action. What do you mean by civil action?
Well, for appropriate civil action, so for restitution or other relief,
Okay.
if it's applicable, these are all depend on the facts. In some circumstances, the facts may not even
Then
bring
that's
that into
third
question.
option, I'm sorry, I didn't catch that one.
Refer the matter to the district attorney for
Okay.
appropriate action.
And then recommend to the member that he or she should resign.
Yes.
so at this point, we should discuss next steps, largely scheduling, but also whether there's any other procedural questions about how our process works when we have a hearing, an evidentiary hearing. Actually didn't bring that, but I'm sure law department will be able to answer any questions about what that looks like, so that the parties can understand what our hearing procedures look like. And perhaps the law department can refer everyone to those sections of the code which spell out exactly what individuals going to hearing before us, what their opportunities are in terms of presentation of witnesses or documentation, cross-examination, and so forth. So why don't we first just consider well, let's see if there's any questions there with respect to actually the operation of our hearing.
Yeah, if,
Or perhaps you could direct everyone just to put on the record.
sure. So section 2.222.040C2 outlines the hearing procedures. In summary, any party that wants to submit materials to the board is required to do so at least 7 calendar days prior to the hearing. Anyone that wants to call witnesses can file with the clerk and also provide to the other party the name of the witnesses at least 7 calendar days before the hearing. And, at the hearing, parties may call witnesses, give testimony under oath, and witnesses are subject to cross-examination. And that's pretty much the general in terms of when the order that's issued by this board will kind of outline, that the requirement that you need to file materials with the clerk and provide to the other party those materials at least 7 calendar days before the hearing, and that if you wish to call witnesses, you have to submit the names to the clerk and also provide a copy to the other party at least 7 calendar days before the hearing. And there's kind of an outline. I think the board has adopted procedures whereby the basically both parties get to make opening statements, and then the complainant will need to present their case. After that, the respondent presents their own case, and then the parties get the opportunity to give closing arguments. And the complainant, of course, has the burden of proof regarding the violations alleged in the complaint by a preponderance of the evidence. After which the board, of course, can ask questions of witnesses, and after which the board deliberates and makes a decision.
Thank you for that summary. And if, a question I'll have is just if any of the parties wish to get a copy of that, should they contact the clerk's office and you'd be able to provide them with those 2 documents?
Yes,
both?
we have those
Okay,
available.
so anyone who wishes to see that in writing should contact Mr. Kyle at the clerk's office. And he'll provide those documents.
And can you be represented by a legal counsel of
Yes.
either party?
Yes. Either party can be represented by legal counsel. So I guess now we should turn our attention to scheduling, with the reminder that parties do have to put together potentially lists and documentation, witness lists and so forth, and get that into the other party and to submit them formally at least 7 days before the hearing. So let's turn our attention to scheduling, and I think at a minimum we should provide at least 3 weeks for people to prepare for hearing. And here it's kind of a balance. You want to do it timely, you don't want unnecessary delay, but you don't want to do it so short that people don't have an opportunity to get their presentations prepared. So I'm going to say, why don't we look at dates kind of from 3 weeks to 6 or 7 weeks. We obviously have a lot of holidays that will interrupt. So some dates that I had just kind of noted. So I think we could look at, for instance, on the early side, and I will say I might check in, although we do not take any testimony from parties at all in these, we can certainly, as discretion and as a courtesy to the parties, I think just get a sense of whether there's any exceptional need one way or the other for more time. but I was going to throw out as potential dates Tuesday, November 29th, or Wednesday, November 30th.
Yeah, can I say
Yes,
something?
yes.
There is a holiday that, I mean,
I
and
realize.
that kind of takes away that whole week.
Yep.
So,
So let's push
my
it beyond that.
recommendation is to, yes,
Okay.
push it.
Okay, so then the other dates a little further out would be, we could look at Wednesday, December 7th, Friday, December 9, or Monday, December 12.
So the 5th through the 9th and the 12th, I have a trial.
Yeah, I've got conflicts on every one of those dates as well.
Okay. So there's lots of trials here. So there's trial in
Yeah,
December,
I've got-
both of you have trials in
I don't
December?
have a trial, but I have deposition set every one of those days.
The trials, the 5th through the 9th, the 12th, the 15th through the 16th.
Oh my goodness, so really December is
Yeah,
pretty,
and the 19th through the 20th, yeah.
okay,
But
okay, so
I
you're
can
kind
also,
of out of
yeah,
pocket on
yeah.
December, really.
so it's December.
Yeah, so I think then, unless, we might be then pushing it into January.
Legal has already said they
Um,
don't, they find that too close in time.
I have a trial January 10th.
Because of
Then, yeah, and you'll be preparing before that, I suppose.
Yeah, and my February is worse, so I'd rather get it done in January if we can.
Yeah, let's look at early January then.
Does she want, do you wanna have it earlier?
Mm-hmm.
Okay,
Yeah.
she would
yeah.
like to have it earlier.
That's what I was wanting to.
29th,
I'm
30th
sorry.
works for me just perfectly.
Okay, so that's,
I can't do it.
Of what,
but-
of,
okay, let's think.
November.
well, yeah, just legally, I mean, I think that presents issues because the week before is a holiday, the 29th, and
But what about if they're both willing to go forward?
Wednesday
What
the
about the
30th,
other
for
woman?
instance.
What's the other woman?
well, yeah,
Are you
she's
the,
not.
are you the complainant?
she's
I'm
not.
sorry, I don't know you.
Yeah,
I don't know.
I see.
okay, yeah, cause I mean, they have to present the information 7 days before.
Right.
So they need the time to
So-
prepare it, so that whole week, if it's like November 29th, it's already November 22nd that all that stuff has to be filed and served, but.
What is, did I mention Friday, December 2nd?
Yes. Oh, no, you did not.
Okay, let's,
I have a conflict that day.
all day?
It's deposition, so
Yeah,
probably.
yeah.
But, you know.
Thursday, December 1st? Let's look at Thursday, December 1st.
Yeah, I know, because
We haven't heard from her.
No, I can do that.
December, Thursday, December 1st is looking possible.
Yes.
Okay, this Thursday, December 1st. And that means that paperwork, witness list and so forth would have to be submitted the prior,
Before the holidays. I
Before-
mean, it's, because it's 7 days.
right, it's Thanksgiving, the prior Thursday's Thanksgiving.
So you're talking about the 23rd, which is the day before Thanksgiving.
So if all paperwork and witness lists were submitted, formally submitted to the clerk's office by November 23rd, Wednesday, November 23rd, we would then, that would be more than 7 days, so that would be compliant. And then we could have the hearing on the morning of Thursday, December 1st. And we typically, yes, it would be here, the location would be here, and I will throw out start
Oh.
times.
I need to think about this legally because 1, 2, 3, 4, 5, 6, 7. The 7th day is a Thursday, which is a holiday, and I really have to think about whether 23rd is the appropriate deadline because you have to do something 7 days before, and the 7th day falls on a holiday.
Oh, I see.
And then the next day, the 25th, is also a holiday. So they, so.
Can they, well, we don't have the
Yeah.
complainant here. I was gonna say if they would stipulate or agree,
Right.
but
Right.
we only have one of the parties here.
So,
I don't know how it works under Tennessee rules, but under federal rules, when you count backward, you actually go back one more day, I think. So that
Yeah.
would be what we were sort of contemplating.
Yeah,
okay, yeah, when it says you have to do something 7 calendar days before, and then the 7th calendar day falls on a holiday, I'm not sure you get less time
No, you get more time.
Yeah, that's what I'm saying, you actually will push it further away, so
Right.
to like Monday the 28th to have your everything filed. And then that creates the issue of, is that really sufficient time for the other side to see what the other side is trying to present, you know? Because if it's the 28th now, that everything is submitted and the hearing is on the 1st, because generally when people get the information, it's the 7 days to allow them time to review whatever the other person is providing or their evidence or whatever.
And-
But now if it's the 28th, that,
So do they have a right to like a certain period of time between now and when they have to turn their records in, you know, file their submission? Because to me, that 7-day thing, if we pushed it backward to the Wednesday before Thanksgiving, that would ensure that everybody would have time to see each other's materials.
well, the 7th day, it says you have to file it 7 days prior to the hearing. The problem is, we can't really, I don't think we can enforce them filing it sooner
Right.
than the 7 calendar
that's what
days.
she's
Because the
concerned.
7th calendar day falls on a holiday.
Right.
So you move it forward to Monday generally, because the Friday is also a holiday. So, and the clerk's office is closed all those days. So, yeah, I don't think we can impose a shorter period essentially
Right.
than
Right.
the code.
Right. And you said under the federal law, when you're counting backwards, under this scenario, you would move it back a day.
Yeah, that's, I believe, I've gotten
I
caught in that
wonder about
situation
this
before, but I
because
believe that that's how it works.
I understand what you're saying, is
Yeah.
that would be tantamount to shortening, in a sense, shortening the time someone has to prepare and submit. Because it would make it 8 days before the hearing.
Yeah, exactly. Instead of
Right.
imposing a 7-day,
Right.
you're now
Right. 8
elongating
days.
the day. Yeah,
Right.
you're saying you have to submit it
Earlier,
And
with
it's-
respect to the hearing.
That's the ordinance that says 7 days,
The ordinance says that,
it's not just
the
our
exact.
rules, so I'm trying to find out.
Right.
Yeah, I mean,
Take it
it
away.
says, it shall, must file the material with the clerk and provide a copy of the same to the other parties at least 7 calendar
At-
days
At least.
prior.
At
But,
least, yeah. So we could by consent of the parties,
well,
at least,
Yeah, I
at
mean,
least 7 days.
parties may waive, but again, I don't, here, I'm not sure we can really, the other party is not here to waive anything. And,
Are there filings as part of these proceedings where they could file something stipulating to the
Yes.
schedule?
Yes.
they could if they choose to, but that is between the parties and I think for me, legally straightforward way, because what parties may or may not stipulate to is between them, and legally I will not really say, well, I recommend you stipulate to this or that so that this can be held at a sooner time. That's between them. I just wanna focus on what the law requires, which is that they have this amount of days, and that's, what it says, they have 7 calendar days to submit their materials.
Can we set the hearing date? The 7 calendar days is what it is, which means that they would actually have until the 28th. If that is a burden on either party, then I would think the onus would be on the party to file something, either asking for a continuance to get a different hearing date or something along those lines. I don't think that we have to put ourselves in the seats of the parties and try to figure out what day works best for them. And I'd say that just because there's so many time commitments, conflicts on the board.
Plus, I think the rule is, it requires them to send the materials to the other party, right? So that can be done at home on
At any
Thanksgiving
time,
if that's what
yeah.
you choose, or you could do it the day before Thanksgiving, you
But it
know?
also includes filing in the clerk's office, the formal filing, and that the clerk's office will be closed on the 7th day prior to the hearing date that
But
works for.
they'll know what that is once they know that we've set a date. They'll know what the rules are. Do they get something that says these are the rules of procedure?
Yes, the order will be specific about when their paperwork is due. I think the concern that Ms. Ecke is raising is that it would be requiring the parties to file their paperwork with the clerk's office 8 days before the hearing, not 7. And their concern is that it's shortening the period. You raise an interesting option, though, that if it's, I think the question is it really is it failing to comply with the order? The order says at least 7 days, and you could argue that 8 days is at least 7 days, and if the parties dispute it, they can seek a continuance.
Well, when you're given a time to do something, that's the deadline to do something.
Yeah,
It
I
has to be
understand.
filed 7
I
days. So
understand.
here, because of the holidays, the actual deadline in
It's the
reality will be
28th.
28.
Yeah.
So long as they file
Right.
28 before 4 p.m., before when the clerk closes,
Yeah.
they are timely. So, I mean, it's your discretion but that gives the individuals Tuesday and Wednesday to review whatever the person has. But, that's your call.
The other question is, do we have the latitude to deem something filed with the clerk's office electronically? If we say we're gonna do that proactively, and then said, if you emailed this to the clerk's office by this deadline, you've complied.
Well, the 28th.
The 28th is the
The
deadline.
deadline.
They are filed electronically, aren't they? Yeah, it's always electronic
And
filing.
we can't require somebody to do something on the holiday.
Yeah, I don't think the electronic nature of the filing disregards the fact that there's a holiday.
Okay.
Yeah.
So at the moment, what we're doing is December 1, Thursday, December 1st is a time when we can hold the hearing. We would, given the holiday and the requirements of the timing, we'd be issuing an order that the hearing will be on December 1 and parties have to submit their paperwork to the clerk's office on Monday, the 28th. We are cognizant that that's not much time for the parties to review it and prepare, but it is what works for a timely hearing so that we do not have to have this dragged on and delayed. I think our council member's suggestion that if we go with this, we can obviously, if any of the parties, if a party feels that's too short to review, then they can alert us to that fact, and we could consider the circumstances and order, perhaps at that point, issue a continuance if we believe that it's deemed appropriate. So, that means what we're looking at right now is a hearing date on Thursday, December 1st, to hear the portions of the complaint that survived today's voting, and a due date of Monday, November 28th for filing, close of business for filing with the clerk's office, the various documentation that will be set out in the order from today's hearing that all parties will receive in writing, and just that goes out electronically, is that right, to the parties?
Yes.
Electronically. Okay,
And what time on the first?
that's the
Okay.
next question, and typically, and again, typically start at 9 or 9:30 or 10, 9 works. Is 9 too early for anyone? Let's set it for 9 a.m. And it will be here. And the paperwork regarding this will probably go out within the next week. Parties will receive it, and any questions can be referred initially through the clerk's office, and who will then figure out who needs to be able to respond to any question that comes in. Okay?
You said 9, is that correct?
9 o'clock.
9 a.m. I was gonna say, maybe the clerk's office could ask the complainant if they are okay with filing the day before Thanksgiving, just to make it easier on everyone. And they, of course, can say no, but I don't think it could hurt to ask.
I think that's a good idea. Okay, Any further discussion or questions on this matter? Agenda item number 4. Okay, so we're all set on that. And let's move on then to item number 5, agenda item number 5, administrative items. And here we'll ask for a brief report from the Metropolitan Clerk's Office regarding a couple of ongoing matters that have were discussed last time.
Yeah, since our last meeting in the spring, I've met with Councilmember Murphy a couple times regarding our discussions around the lobbyist code. She has met with several of the registered lobbyists in Metro and gathered some feedback from them. Many of their concerns were really related to the format of their reporting form and not necessarily the process or the requirements of the form. So this past year was the first year that they completed that new reporting form. And at that time, it was only available as a PDF on our website. It was 4 pages long, but depending on the number of clients that they registered, it could end up being several more pages. So some of the lobbyists that Ms. Murphy spoke with requested like a scaled back or simpler form. Others requested the ability to have an online form rather than just a PDF. And I discussed with Ms. Murphy that my office could probably address some of those issues internally without requiring a change in the code. So I'm going to be working with ITS and the web team to kind of create an online reporting form that might be more user-friendly for that type of report. And then another topic that we discussed the last time at our Board of Ethical Conduct meeting was the length of time between the filed complaints and the deadline for a report from the law department. Previously, the board, along with our legal representatives, expressed the desire to align the deadline requirements from both the standard of conduct as well as the lobbyist code. The standard of conduct deadline is 14 calendar days, whereas the lobbyist complaint is 14 business days. Councilmember Murphy was not in favor of extending the deadline, particularly for the lobbyist complaints, and her reasoning was based on the short amount of time it takes to introduce and pass some council legislation. For example, a resolution can be filed, placed on the council agenda, and passed at a council meeting in under 10 business days. So if a lobbyist complaint was filed, potentially the resolution that the offender was lobbying for could be adopted by council before the law department report is issued. And her concerns were strictly around the lobbyist code and not the standards of conduct. And then just a final report from my office, we're getting towards the end of the year, and we'll be sending out notices to the lobbyists as well as all Metro departments for the required annual financial and benefit disclosures that'll be due by January 31st.
Okay, thank you. Any questions or comments about any of that? In our, I think I don't want to today get into a discussion about some of the other questions that we discussed last meeting in terms of more regular the proposal to have established quarterly meetings of this board, so that as matters come up, even administrative matters come up, we have a place, given everyone's tight calendar. I'm not sure this is the day or the time to have that discussion, but I would ask if you could, our clerk, to include that in our next meeting that we have, so let's revisit that question. And in the same vein, I want to just alert members to the fact that we've also been asked by another Councilmember Allen, to consider a possible bill that she has thought about bringing, which would relate to essentially the Metro government covering up to a certain amount legal fees for public officials who are here before us, but then are determined to have not violated the code. So there's some language being considered. It is not, I believe that it was the draft, I believe that a bill was taken off notice, so that there's not a schedule for this to be heard, I believe, by council.
It was deferred indefinitely at the last meeting.
Deferred indefinitely, but Councilmember Allen has asked us as a board for some thoughts and feedback on that. Again, I think today's not the day to have a long discussion about it, but I wanted to alert you all to it, to consider kind of pros and cons and how it would be folded into our process, since you're now all quite familiar with how it works. So give it some thought so that we can provide thoughtful feedback back to Councilmember Allen as she's thinking about with her colleagues how she wants to proceed on that matter. And it's not clear whether it would be at the council level or at our level of making a decision. So I just want to put that out there for thought, so that when we next meet, we can consider that issue. Okay? All right. Any thoughts or comments, questions? Okay, then item number 6 is just next steps in scheduling. We have our next schedule. We will, next time we meet, perhaps at the end of the hearing, perhaps we can have a bit of an administrative meeting as well, and consider these other administrative issues for discussion at that point. I'll just remind everyone that we meet the first Monday in March, when we hold our elections for chair, so everybody think about that. First Monday in March. It's a mandatory meeting for us, as it is I believe it's in the code itself, that we meet and receive the lobbying data, the lobbyist information. Okay, so just try to hold your dates to the extent you're able to. Okay. Any other questions or comments before we adjourn? Hearing none, okay. The meeting is now adjourned. Thank you all.